Welcome back. We're about 2/3 of the way through our program, and joining us next is Fredrikson's Dulce Foster for her second feature. Since we've already introduced her, I'm going to let her dive right in. Dulce?
Thanks very much, Mary. I am happy to be here. Good morning. Since this presentation is only half an hour long, it's going to be pretty high level discussion about what to do when you're responding to a government investigation. I'm only going to hit some of the most important things to be done. For any white collar attorneys or even experienced criminal defendants in the audience, this is going to seem like familiar territory, but I'm hoping that for the rest of you, it'll be new and informative. So next slide. What I've created here is a checklist of things to consider when you find yourself on the wrong end of a government investigation. So this is part one. Part one is just the first steps to consider. These are the things that you're going to need to go to immediately when a government investigation hits you. And now I'll go through each of these steps in details. Next slide. So as a threshold matter, it's important that you read the signs. And what I mean by that is just know when you're under investigation. Now, this may seem obvious to many of you. I know when I'm under investigation. And of course, it is obvious when a truckload of FBI agents shows up at your door with a search warrant and starts taking your computers out. But what about the rest of the time? There are many, many different ways that government investigations can begin. One of the most common ways is the dreaded grand jury subpoena. When you get a grand jury subpoena, it's often difficult to know how to read the tea leaves, to know what's going on. You may be just a witness. You might be a third party that is in possession of documents that the government wants. Or you may be a target, or you may fall into this middle category that the government likes to call subjects. These are organizations and individuals where the government hasn't really made up its mind yet about which bucket they're going to put you into. So it might be very unclear, even to the prosecutors who are involved, which bucket you fall into and whether you're a target of that investigation. It's important to consult with white collar criminal defense counsel, FCA litigation counsel when you get something like this, so that you can help them, or so that they can help you figure out what's going on. Another common way that government investigations begin is through civil investigative demands. These are tools that assistant U.S. attorneys use and leverage when they are conducting investigations. Earlier in this morning's session, I talked about this period of time between when a False Claims Act whistleblower files a complaint under seal and the government is considering whether or not to intervene in the case. And they will do their own investigation of what's going on. Oftentimes a company won't know that the case exists because it is filed under seal, but they will find out when they get a civil investigative demand from the government asking for information so that they can explore the allegations that a whistleblower has made. So that is one common way that these investigations begin, and one common way that companies find out that they are in fact under investigation. They can also begin with federal agencies or state attorneys general who may issue subpoenas. These agencies often work together with the Department of Justice. So you might get a subpoena from an OIG, or you might get a subpoena from a state attorney general and not realize that there's also a Department of Justice lawyer kind of lurking in the background, listening to what's going on, watching what's going on, and deciding how to proceed. As we've talked about many times during this session today, you can be the subject of a False Claims Act complaint, either a direct complaint from the federal government or a key TAM whistleblower complaint through a relator. Understand that it is really common nowadays, that I think more so than it used to be, for these cases, these False Claims Act cases, to be run in tandem with criminal investigations. So it's often the case that a company will initially start out understanding that they are the subject or target of a False Claims Act complaint, and then find out that the federal government is also looking into whether or not to bring criminal charges. They've gotten much, much better. The criminal and civil divisions of the Department of Justice have gotten much, much better about coordinating with each other on these things and sharing information than they used to be. You can learn about the fact that you're under investigation from other intelligence sources. So just the general rumor mill, the grapevine, your sales reps might hear about something in the field. You might read news reports. that suggest that there are some red flags that you need to look at. There might be social media posts. There might even be an industry sweep that affects everybody in your particular area of practice, in your industry, that might raise a red flag for you to take a look and see if it's possible that you might be under investigation. Another way is these informal requests that you might get from government agents or lawyers that ask you to provide information or to meet with them to discuss a matter. And it's kind of hard to know sometimes how to interpret things like that. It might be a simple administrative matter that you can clear up just by going to meet with that lawyer and talking to them. I think everyone here on this call knows how important it is to be cooperative with the FDA and to keep the lines of communication open with that agency. But you should always be aware that it could be something much more serious. And it's often difficult to tell if the agent mentions criminal liability or if the allegations are particularly serious, if the tone of the meeting seems to be hostile, if they try to bring other government agencies to the table, or if it just feels wrong. Just take a step back and stop and consider getting outside counsel, and consider the possibility that you might be under investigation. Next slide. So it's important not to be misled. You need to know who is on the other side of the table. So if a government agent or a government attorney asks you to attend a meeting, it's really important. If this is somebody that you don't know, if it's an individual that you haven't worked with in the past, find out. This may seem like an obvious thing, but it's not always obvious. And I've got a recent example that I can talk about. A fairly sophisticated, publicly traded medical device company. So we're not talking about a mom and pop shop. This was a big company, had an audit that they were undergoing, and they got a call from a government lawyer who said, I'd like to meet with you. And they set that meeting up and they agreed to go, and everything was all ready to go. And they didn't notify their outside counsel until the night before this meeting was supposed to take place. They called their attorney and they said to her, yeah, we've got this meeting taking place. And she said, well, who's the lawyer that you're going to be meeting with? And they said, oh, I don't know. I think it might be somebody from the Department of Justice. And all the bells and whistles and red flags started going off. And she said, who do you think it is? And they started doing some due diligence. And turns out that the person on the other side of the table was not only an assistant U.S. attorney who was looking at the case, but it was a prosecutor from the criminal division. The client was in a bit of denial, was saying, no, it can't be possible that we're under criminal investigation. This is just an audit. We were going to clear it up. It ended up taking about 5 lawyers in 2 different law firms of meetings with the client to convince them that, no, they really should not go to this meeting. And so the meeting was canceled. The lawyer for the company ended up connecting with the DOJ attorney, the assistant U.S. attorney on the other side of the table, and confirmed that, in fact, that company was under criminal investigation. Had they not stopped and paused and stopped going to that meeting, they may have made some very serious admissions against their interests and damaged their criminal defenses in the case. So really important to know who you're meeting with. Next slide. Okay, so this is something nobody really wants to think about or talk about: search warrants. Nobody wants to think it's going to happen to them, but really nothing can be more disruptive or cause more panic in an organization. So I think these situations deserve special attention. And even if you're certain that it's never going to happen to you, it really pays to have a basic, at least a rudimentary understanding of what to do if you're faced with a search warrant, because if it does happen, you are not going to have time to think about what to do at the time. It's going to be all panic and chaos. So here are some basic pointers for responding to search warrants. First of all, allow access to the premises and then get out of the way. You don't want to be, locking your doors and telling them not to come in, or doing anything that could be interpreted by the government as obstruction of justice. Be polite and professional, but do not answer any questions. They have a very common approach where they bring a whole bunch of agents in and just fan out in an organization and start asking as many questions as they can before the company can get their lawyer on board. Don't let that happen. Make sure that you are not answering questions at the time. You can unlock file cabinets and offices, but don't provide computer or phone passwords. This could be a waiver of the Fifth Amendment privilege against self-incrimination. The decision to provide passwords and computer access that's a discussion that you need to have with your outside criminal defense lawyer before you do it. You should immediately contact your outside attorney, or if you don't have one, find one, and have them come on site while the search is ongoing so that they can run interference with the government agents for you. Ask for a copy of the search warrant and the inventory so that you know what they've taken and that you confirm that the warrant is actually real and proper. Identify potentially privileged materials that they might be taking, and your lawyer should do this and for you. Object to the seizure of any attorney-client privilege materials, and if they've already been taken, then your lawyer can talk to the prosecutor who's involved and ask to have those privileged materials returned. Now, this could be a lengthy discussion that they'll have. The DOJ often, and one of the mechanisms that they commonly use in situations like this is called a taint team. And this is, they'll say, it's kind of a fiction. They'll have the attorneys who are prosecuting the case and the agents who are investigating the case, and they'll set up kind of a Chinese wall between them and the another part of the office, and they'll say that these agents and these attorneys on the other side of the office can look at all of the documents and materials on the computer and return the privileged information. This has been routine for years for the Department of Justice to use this process, but recently courts have been calling this process into question, and defense attorneys and defendants have been challenging this process as unfair and potentially biased. And there was a 2019 Fourth Circuit case where the court came down and said, no, the taint team process can't be used here. So there are other ways that privilege review can happen. One way, and I've seen the government agree to it on maybe one occasion, is to ask that the attorneys for the company be allowed to review the computer information and hand over any documents that are not privileged. So give us the computers back, we'll look at it, we'll give you everything that's not privileged. The government often objects to that process, so I haven't seen it done a whole lot, but it has worked in some cases. Another process would be to ask that the court who's involved, there's always a court behind a grand jury subpoena, appoint a special master to review the computer and determine what's privileged and what's not. When the agents are on your premises, consider closing for the day and sending your employees home so that they don't get targeted for some of these interviews that the agents are going to be asking for. You do want to tell your employees that they should not interfere with the government agents, and you should warn them against deleting or destroying any records. When sometimes people panic and they're like, oh no, I've got some bad information on my files, those agents are at the door, I'm going to delete everything. That could cause real problems, and I'll talk about that in a bit. But an immediate message to the employees: don't be obstructive, don't try to destroy stuff. You should not instruct your employees not to talk to the agents if they want to. Telling your employees that they're not allowed to talk to the government agents, again, could be interpreted as obstruction of justice. You can tell them that the decision whether to be interviewed or not is up to them. It's entirely the employee's decision. You should tell them if they do decide to talk to government agents, no matter what they do, they should tell the truth. Those untruths have a way of getting out. And if you're liable for what your employees do. And if your employees lie to government agents, then the company is lying to the government agents. You can request that company counsel be present for employee interviews, and you can offer to bring in separate counsel to represent the employees individually. Next slide. So what if you're not being searched? When do you bring in outside counsel? If you're being searched, it's pretty obvious. Bring in counsel immediately. If not, how do you make that judgment call? I think a lot of that depends on and I think Sandra talked about this a little bit, it depends on the sophistication of the in-house legal team. It depends on the bandwidth of the in-house legal team. And it also depends on the seriousness of the issues that are involved. It may make sense for you to handle the issue on your own if your team is used to handling government subpoenas and if you're pretty sure that you're just a witness. If the government employee is somebody that you regularly work with at the agency and the questions being asked are routine, you probably don't need to bring in your outside lawyer. But if it's something serious, if it's threatening, if it's hostile, if it appears that you have criminal exposure, absolutely bring in an outside attorney right away. I have, in counseling clients over the years, found that it is often the instinct of, particularly in the medical device and pharma space, to cooperate and to say, well, I don't, I want to appear cooperative. I don't want to bring in a lawyer because that's going to make me look defensive. But, and so I've encountered lots of clients who are concerned that bringing in a lawyer from the outside will send the wrong message. But the problem is, if you let your cooperative instinct run amok, you could end up, getting yourself in a situation where you incriminate yourself, and that is far worse. You need to understand that retaining a lawyer is not in itself evidence of guilt, and that the Department of Justice is used to seeing lawyers on the other side of the table, even for routine third-party document subpoenas. I handle those all the time. It's not a big deal to have a lawyer running interference for you. If the questions that you're getting are coming from the Office of the Inspector General, consider bringing in outside counsel. An OIG investigation could be a prelude to a false claims or a criminal case. And as I mentioned before, the Department of Justice might already be silently monitoring what's going on. And it really is a mistake to try to handle things internally if the Department of Justice is on the other side of the table. If you once you do bring in an attorney and you have outside counsel come in, there are many different things that they can do for you. They can, first of all, act as a buffer and communicate with the government on your behalf without the risk that the things that your lawyer says can be directly attributed to you as incriminating statements. They can contact the government lawyer and get information about the investigation. They can find out what they can about the allegations that are being alleged. Sometimes the prosecutors or the False Claims Act attorneys on the other side of the table will tell you a lot, and sometimes they won't tell you very much at all. It really varies from case to case. They can also tell you what your status is. Are you a mere witness? Are you a target? They can negotiate reasonable deadlines for document production. So if you get one of those CID requests for documents and it's very overburdensome and they want it all in a week, your lawyer can call and say, you know what, here are the things that I can give you right now, but there's some things that you're asking for that's going to take months to put together. It's really unreasonable. Let's figure out how to establish reasonable limits to this. So that's another job that your outside attorney can handle for you. And they can also direct any internal investigations that you decide to conduct in parallel with the government investigation so that you can find out what's going on in your own company. They can do that under a stronger privilege than in-house attorneys will have. And one example I like to pull out for folks is that if you are in the United States, there's a fairly, I think, relatively in this country, strong privilege, attorney-client privilege that applies to in-house legal communications when it's clear that the in-house lawyer is providing legal advice and not providing business advice. Sometimes that's not entirely clear, and that's why the outside attorney privilege can be stronger. But if the investigation actually has global reach, if it's a foreign corrupt practices investigation or something that reaches outside the United States, then you may have really serious problems trying to claim privilege as an in-house attorney, because in many countries, the attorney-client privilege is not applicable to in-house lawyers. And so in those circumstances, it really is extremely important that you hire an outside lawyer to handle your investigation for you. Next slide. So the next thing that you need to do immediately is lock down your documents. You got to do that as soon as possible. Since medical device and pharma companies are such highly regulated businesses, I think most of you probably already have sophisticated document retention policies in place, but not everything is going to be captured by that. You need to work with your IT team to turn off any routine document deletion programs you might have. Many companies have a robot that comes in and just deletes stuff after 2 years. You're going to want to turn that off as to any documents or emails that might be within the scope of the investigation. You should try to capture everything that's potentially relevant on central servers. And if you have the capacity to execute a silent litigation hold, where you just capture and freeze frame the documents and emails that are on the server at the time that you find out about the investigation, you should do that. You should also work with your outside counsel to draft and distribute a document hold notice or document preservation notice, and make sure that that gets distributed to employees with potentially relevant information as quickly as possible. And if you're concerned that you might have an employee who is implicated and that employee might destroy evidence, you should think about and seriously consider putting that individual on administrative leave and taking possession of any of their company issued computers or cell phones immediately. The government is very good at examining computers and figuring out when significant information has been deleted in response to an investigation. It's the kind of thing that can actually turn what started out as a false claims investigation into a criminal one. I'm aware of at least one device company that had to deal with this issue where they had a false claims investigation going on. One of their employees intentionally destroyed a whole bunch of documents and records that were directly relevant to the government's investigation. The government found out about it. The company ultimately got criminally charged, and the fact that those documents were destroyed was one of the government's, key exhibits in the criminal trial. Just understand that the DOJ sees hiding evidence and destroying documents as an indicator of guilt. So you want to take every step you can to prevent that from happening, either intentionally or unintentionally, because even unintentional deletions can be misinterpreted by the government as intentional ones. Next slide. Okay, so now you've managed to get through the first few days, you've retained an attorney, and you've locked down your documents. What's next? Next slide. First of all, develop a communication plan. Be thoughtful about how you're communicating about the case. First of all, notify upper management. That's going to be a tough discussion to have. Often the feedback that you get is, well, let's get this wrapped up. I want this over with in a couple of months. And, how much is this going to cost? This kind of investigation can be extremely disruptive. It can be extremely expensive. And most of these investigations will go on for years, not months. Upper management needs to be counseled on that and their expectations set. You also should develop a strategy for notifying your employees. And this varies from case to case and from company to company, what that strategy should be. Some places and with some investigations, it makes the most sense to just tell the employees that have a need to know, those who are most likely to receive interview requests or requests for documents that are in their custody or control. In other companies, in other situations, it might make the most sense to send out a blast written statement to the entire workforce. This is often the case with smaller companies and companies that are facing investigations that are likely to end up in the media. It's often not a good thing for your employees to find out that their company is under investigation from the Star Tribune, as opposed to finding out about it from the management of their employer. So consider those factors when you develop your communications plan. Warn your employees who do know about the investigation not to gossip about it. The last thing you want to do is have the information spread via the water cooler. Rumor mills can create bad evidence, and they can create misinformation that causes business disruption and panic. It is important that employees know that if they are talking to other people, either at home or at work, they could actually be creating new evidence and turning those individuals into witnesses in the case. You should also instruct your employees not to talk to the media about the case. If there is a media implication, then it is a good idea and strategy to have a point person within the company who is assigned to handle media inquiries and simply direct all employees to that person. And for any employees who are involved in collecting information or documents on behalf of the company, it is important to let them know about the importance of confidentiality and the attorney-client privilege, and make sure that they're aware that their communications with the company's counsel cannot be shared without potential waiver of that privilege. Next slide. Your communication strategy, if you're dealing with a government investigation that could end up in the press, should have a component that involves managing the media. You should consider retaining a PR firm to assist you if it's something that is likely to have a significant negative media blowback. And you should discuss in advance how you're going to handle media requests. I think most lawyers would advise their clients against giving interviews to reporters while a government investigation is ongoing. On the other hand, no comment responses, if that's all you say, can often be extremely unhelpful and cast a company in a bad light. So you should work together with your PR consultant and also with your outside counsel to figure out how you're going to respond to that. One thing that some folks do will be to take down the media's questions and very carefully consider how they're going to answer those questions and develop kind of well thought out written responses to the questions as an alternative to participating in direct interviews with a reporter. Another thing you might want to consider if you are aware that this is coming down the pike is to get out in front of it, have a conversation with your PR consultant in advance before the media contacts you, and consider having a written statement prepared before the coverage actually hits. Next slide. You also have to consider whether there are any mandatory reporting obligations that apply when you become aware of a government investigation. If you're a public company, obviously, one of the things you have to consider is whether the investigation meets the materiality threshold for triggering SEC disclosure requirements. Have you learned anything that would trigger MDR requirements that have not yet been met? Are you under a government contract, a corporate integrity agreement, an acquisition agreement, some other contract that requires disclosures? Consider all of these things when the government investigation hits the door and make sure that you're not missing any steps. Next slide. I don't need to spend a whole lot of time on this one, but it's just a reminder that if a government investigation comes your way, you should always check your insurance policies and make sure that you notify your insurer about the investigation in time so that you don't miss the triggering event for coverage and you don't blow the deadlines and lose your insurance coverage because you haven't notified them about what's going on soon enough. Next slide. Next, consider, depending on the circumstances, and it's not always the case that you know enough to be able to launch your own parallel investigation or might not want to, but in many cases, it is a good idea to conduct your own parallel investigation so that you can learn what the facts are within your company that the government might be investigating. I always start by investigating the investigation itself and gathering as much information as I can from whatever sources are available to try to find out what the government actually is getting at. Your attorney, first of all, should talk to the government's attorney and ask as many questions as possible. Sometimes, as I said before, you can get a lot of information that way. Sometimes you don't come up with a whole lot because they're playing their cards fairly close to the best, but do the best you can. You can also find out a lot from court record searches and internet searches about related cases or parties. Always look on PACER, which is the sort of the federal government court case system, to see if there's anything related online, if you're aware of other individuals or companies who might be involved. Communicate with your employees, find out what they know, and ask them to let you know if they get contacted for interviews. And then if you are aware of other companies or individuals who are involved in the investigation and they're represented, always reach out to their lawyer to find out what their lawyer might know. And then consider conducting your own internal investigation of the facts as well. And Amanda covered a whole bunch of different points for conducting these internal investigations. But I always recommend when there's a government investigation that's ongoing that the investigation be conducted by outside counsel to maximize privilege. Understand that the results of your investigation could potentially end up being disclosed to the government. So there's some risk there. And, particularly if there has to be a third-party disclosure of the investigation findings, that could end up opening a door that causes the court to say that the investigation results need to be disclosed. So always bear that in mind. Do the most you can to maximize privilege in conducting that investigation. Mark everything you should, give your upjohn warnings as appropriate, et cetera. But it's really often a good idea to conduct your own investigation because that is the big thing that's going to help guide your litigation strategy and help you marshal your defenses. Next slide. If your company is under investigation, you're likely to be dealing with requests for interviews of your employees at some point. As I said before, it is the employee's decision whether to participate or not, but you can ask your employees to let you know if they are contacted. And if that happens, one of the first questions that you're going to have to consider is whether to retain an attorney to represent them individually or not. In the criminal defense world, we can't represent more than one party to a targeted criminal investigation. And so that means that the same lawyer cannot represent the company and its employees, and there has to be separate counsel retained if individual representation is needed. This can be really expensive, but in some states, and in Minnesota is one of them, advance payment of legal fees may actually be required under state law, depending on whether the employee acted in good faith and thought they were acting in the best interests of the company at the time that they engaged in the behavior that is being investigated. If you do end up retaining an individual attorney to represent your employees. You can ask the employees to sign what's called an undertaking or a statement in which they would commit to repaying those fees if it turns out that they actually did not act in good faith, that they were a rogue, bad employee actor. But the reality is, even if you have them sign this undertaking type of document, the likelihood that you're going to get those fees recovered is pretty low. Often a good strategy, though, to have them sign it to make sure that they're aware of their obligation to repay and that they're understanding that. Most importantly, though, I think one reason to hire outside counsel for your individual employees is that they're better able to defend themselves if they're represented. They're better going to know what their rights are, when they can talk, when they should talk, when they shouldn't talk. And that is often going to be in the company's common interest with the employees. Another thing that we have to consider is whether to enter into a joint defense agreement with the counsel for the employee. And that's a whole another seminar that I could give on that. There's a common interest that sometimes applies that allows you to keep your communications with counsel for the employee's counsel protected from disclosure. Now, there's a recent Minnesota Court of Appeals decision that came down in June of this year that held that there is no common interest privilege in Minnesota. That case is currently being challenged in the Minnesota Supreme Court. So I think there's going to be another chapter written on that. But most of the time in federal court, the common interest privilege is recognized. Next slide. See that I'm running out of time, so I'm going to handle this quickly. Remediation is a consideration that is highly fact specific. It's something that you should consider if you have facts that you uncover in connection with your response to the government investigation. But it's also something that has some risks to it. Changing your policies and practices may be viewed by prosecutors as an admission of guilt, and you need to weigh the benefits and against the risks of remediating. In some cases, you don't have a choice. If your device is killing patients, you have to issue a recall. If you've overbilled Medicare, not refunding is going to be a separate violation of the False Claims Act. You have to do something to remediate that. On the other hand, if you truly have not done anything wrong, then changing your policies in an attempt to remediate something that wasn't wrong in the first place could send the wrong message. So this is something that needs to be carefully thought out and considered before you make any changes. Next slide. And finally, don't panic. Whatever you do, try to stay calm. I've been through many of these investigations and seen everything from indictments to acquittals to the government just walking away. Anything can happen, but it is critically important for you to keep your head and make thoughtful, rational decisions, because you're going to have a long road ahead of you and you'll need to be able to get through it with the most carefully thought out approaches available. Next slide. Thank you for your time. I see that I'm out of time. If anyone has any questions, I'm happy to address those after the session, or you can send me an email.
Great, thanks, Dulce.